I don't want to be at the mercy of a jury to like me or not. We've been talking about Castle Doctrine. I'm a big proponent of firearms. I believe in 100% self-defense. If you enter my house, you surrendered your life. That's my take on it. And it's such a hot issue right now. Everybody's talking about it. So we have finally Pierre Poilievre talked about it. You had even Doug Ford talked about it. Once again, Daniel Smith said it the best. But the whole goal was to have an actual lawyer to come on the show. And I found Hatim Kheir from Charter Advocates. And here he is. How you doing, sir?
Hey, how's it going?
Hello, I'm good. How are you?
Not too bad. Thanks for showing up. Thanks for giving us your time here.
So I'm going to start right into it because there was a great article this morning that I found in the National Post that kind of blew my mind, because this is exactly how I see the self-defense in Canada, and Castle Doctrine is not even a conversation. But the article said something along the lines of, in Canada, you can shoot, stab, and plunge in an intruder who comes into your home with hostile intentions, and the legal system will almost always determine that you didn't do anything wrong. But the problem, according to self-defense advocates, is that this determination often comes as the tale of an end furious and years-long legal battle. Does that make sense to you? Because this is exactly how I see it.
Yeah, I think that's about right. Canadian self-defense law is all about reasonableness, but it's reasonable. It ends up being decided by a jury. So, it's being decided by, hopefully reasonable people that are being selected for the jury, other fellow normal Canadians, right? But the problem is that's a long time to get there. For a murder charge, you're looking at many years of being under those charges until you get to a trial, and then probably a lengthy trial. And at the end of the day, let's say you get an acquittal and, you're happy you got acquitted, but that's a lot that you've just been put through.
And how much did it cost?
You did nothing wrong. Yeah.
So do you think that sometimes the process is the punishment in itself?
Yeah, I think it is. It can be a punishment for people to just be put through that ringer. I mean, to spend years not knowing if you're going to get a life sentence. Because that's the other thing about self-defense, right? And this isn't necessarily something I'm criticizing. It's just what it is. But if you, you end up killing someone, you're defending yourself, you go to trial, assuming there's no question about whether or not you ended that person's life, you're looking at either a murder conviction, which carries a life sentence, or you walk out free. There's no in between there. So that's a pretty stark reality to be faced with for 2-3 years while you're waiting to see what happens.
Yeah. So is there any sort of aspect in the law or ability for the law to say, yes, we do have this standard of proportional force or reasonableness, as we've heard, but is there any thought given to the fact that the person in the house has a split second to make a risk assessment that he really has no idea how to make, because he doesn't know the person, he doesn't know their intentions, he doesn't know if they have a weapon hidden somewhere that he can't see it, and that just seems like an extremely unreasonable burden to place on someone who is simply defending their home and their family. So my question is, does the law just not factor that in whatsoever? I guess the split seconds that you only have to make that calculation?
There's a place for that. So what the actual criminal code requires is that you have to believe on reasonable grounds that force is being used against you or someone else. You have to be doing what you're doing for the purposes of defense. So you can't go, it has to be for the purpose of defending yourself. And then overall, whatever you did has to be reasonable. But there are cases that have said, where the court has said, a person isn't required to weigh things to a nicety. That's the phrase in the court. Okay. But basically, yeah, you have to acknowledge the actual decision that the person's being faced with in the moment, where they don't exactly know what's going on. And you have to assess what they're observing in the moment.
Sure.
Do you think that we are capable of removing that reasonable aspect of self-defense? Because I'm a martial artist. I've trained all types of martial arts. I've had to defend myself. I've had to defend people in the past, and I spend a lot of time in the U.S. I'm a big fan of Castle Doctrine, self-defense, carrying a firearm. But is there a way for us to remove that reasonable aspect or proportional aspect from the law? Because this makes zero sense to me. If you're coming into my house as an intruder uninvited, I will not be weighing your intentions. I will assume from the get-go that you're here to murder my children. I will go to the worst case scenario because you weren't invited. You don't deserve, you're not supposed to be here. I'm not here to have a conversation with you. I'm there to dismantle the threat and to protect my family. At the end of the day, my family's lives is a lot more important than the one of an intruder. So is it possible for us to have that put black on white to say that there's an intruder, this is what happened, it's okay, high five, you did your job, you protected your family, have a good life, we're going to take care of the body?
So your question is it possible? It is possible. The self-defense rule is codified in the criminal code. So it's written out. That's a law that's passed by Parliament. Parliament made it what it is. They can change it. They changed it in 2012. It used to read differently. So it can be changed, politically, practically. I don't know. It depends on the government of the day that's actually in Parliament.
Back to the proportional force standard. I think, if someone's describing that, an obvious one would be like, well, if they have a knife, you can't shoot them. Or if they're unarmed, you can't stab them. Like, basically, if they have a knife, you could go after them with a knife. But it's not, proportional force isn't just about weapons. What if the person is unarmed, but they're 6'5" and 250 pounds of muscle, and it's a 5'5" woman and 100 pounds? Would her using a weapon on an unarmed person be deemed not proportional? Would she be expected to go toe to toe with this guy?
No, not necessarily. Like, because this is the ultimate standard is reasonableness, and this is something that goes to a jury to decide. I can't say yes or no, but the criminal code does list things that the court should consider, the jury should consider. So there's the nature of the force or threat. There's the extent to which force was used. There's the size, age, gender, and physical capabilities of the party. So that kind of goes right to what you're saying. Mm-hmm. But there's also the person's role in the incident. So that can kind of go to the idea of you're just sleeping in your bed versus you're out on the street picking fights. Just sort of looking here. Whether or not any party to the incident used or threatened to use a weapon. So that kind of also goes to the idea, is the person breaking into your house using a weapon or not? So there's no hard and fast rule that someone breaks into your house with a knife, that using your gun is off the table, because you can't bring a gun to a knife fight. That's not a rule. Sure. Okay. So that reasonableness standard, it's difficult to make predictions about what'll happen in a case in the abstract.
There's so many factors, right?
Yeah, but it is something that you kind of have to ask yourself whether or not you trust a jury making that decision.
Mm-hmm. Sure.
Because at the end of the day, I read the criminal code, especially section 34 and 35. One of my old clients is a prosecutor for Oakville, or at least used to be, and he printed me the self-defense part of the criminal code, and my jaw dropped. I'm like, basically what you're saying is that I'm at the mercy of the judge/jury. They will decide. It's a massive gray area. There's no black and white saying, yes, he was in your house, whatever. So I understand that you're saying that it's possible to have it changed, like Parliament has the power to change it. So potentially it would be possible to happen on, let's say, a federal level. I think we can all agree that this is never going to happen in Canada, not with the Liberal in power and our conservatives not being real conservatives, being white, like really blue-washed liberals. But would it be possible for a province to do it? Because we know, if you look at what Danielle Smith's doing in Alberta, she has spoken for gun rights in the past, and she's doing something different than every other provinces are doing in Canada right now. So do you think that it would be possible to do similar to what the states in the US are doing? Because Castle Doctrine is a state law, is not a federal law. Like there are states in the US where there's no Castle Doctrine. But could we copy that and make it happen in Canada? Is there a way for our provinces to install a Castle Doctrine, let's say Alberta, into their legislation or into their criminal code so that people have the right to defend themselves?
I want to answer your question. It raises a lot of interesting points. I kind of want to answer it on two levels. So
Sure.
the first level here is that what authority do provinces have to make rules in this area? So under the Canadian Constitution, there's a division of powers. The Constitution just lists certain things that the federal government can do, lists certain things that the provincial government can do, and criminal law is under the federal powers. So that's why the criminal code is a federal act passed by Parliament. And so the provinces have no authority to legislate criminal laws. And so they can't change the self-defense provision. They can't change how it applies in their province specifically. It is what it is. So they can't change that. Maybe some provincial lawyers will come up with a creative argument how it slots under one of the provincial heads of powers, but I think that's a stretch. There's not really a home for it under what provinces can do. But can I just answer the second level I want to approach?
Yeah. So the floor is yours.
So what provinces can potentially do is if there is a provincial government that has a problem with how these rules are being applied or the way it's playing out. We spoke earlier about this whole charge first and then just wait to see what happens at the trial approach. Provinces are actually in control of the prosecution of most offenses. So in the case of this man in Lindsay, Ontario, he's being prosecuted by provincial crowns. And so that is where the province gets an element of control, and crowns have discretion to withdraw charges. They can withdraw charges, generally speaking, if there's no reasonable prospect of conviction. So right off the bat, crowns should be asking themselves whether or not self-defense is present, and if so, does it make sense to take this to trial? But then two, they can also withdraw charges if it's not in the public interest. And so the government will form these policy manuals. Like the Attorney General's office will form these policy manuals that'll then go out to the crowns throughout the province that they have to apply. And the policy manuals will set out things like, for drunk driving, if you're charged with impaired driving, depending on what the reading is, does the Crown have discretion to, offer you some sort of a lesser charge that you can plead out of? Is it your first offense? Have you been doing this before? And that'll tell the Crown what they can and can't do in that scenario. So in the case where there's a self-defense being used and it ends in a homicide, a Crown policy manual could reasonably say, you got to ask yourself, did this happen in someone's home? Did the intruder, did this happen at night? Did the intruder break in? Was he invited? And those things could direct Crown attorneys to withdraw these charges and get them out of the system.
That's very interesting. So you're saying officially by the law, they can't really do anything, but sort of by the back door a little bit, by changing the culture of giving specific guidelines that the attorneys will then use to make their decisions, they can exercise a modicum of control over this issue, or provinces can.
Yeah. So that's where provinces do have control. They have control over the prosecution of these offenses. And so that is where they could exercise their power to say, we're going to do things differently here in Alberta or wherever the case may be.
Yep. Interesting. I want to go back to something you said earlier. You said that they actually had changed the wording in the law not that long ago, maybe, 10 years ago, 15 years ago, or whenever, I forget the date. Do you remember offhand what it was changed from?
It was a bit more complicated before 2012. So that's before I was a lawyer, but you read the
even the direction.
Yeah.
Did it get more strict on people defending them homes, or a little more lenient?
So for example, the law distinguished between a provoked assault or an unprovoked assault. And it asked, like, did you cause, what kind of harm did you cause to the person? Was it intended to cause death or not intended to cause death? Was it necessary or not necessary? So the real shift in the law was simplification.
Okay.
So the law reads a lot simpler now. It's just, was it reasonable?
Yeah.
It was a change that happened under a conservative government, for what that's worth. Arguably, it was made, I think, to be a little bit more forgiving to people using self-defense.
That's how I read it, just based on what you're saying there.
But it does put that call in the hands of the jury, so maybe it creates more uncertainty. You could argue that for sure.
Is it too much? Why is it so complicated in the criminal law, especially, to be very direct? To just say, even if we don't have a Castle Doctrine, why can it not? Basically, because my problem is I'm always going to come back to the same thing. I don't want to be at the mercy of a jury to like me or not. Because let's be clear here, this is what happens. Because I'm abrasive. Most people don't like me in real life. I'm a big guy. I look like I have a big mouth. And you know what? I don't want my safety or the safety of my children or the safety of my wife, of my family, or my liberty to be based on somebody's opinion of me. I want the law to say the guy that was not invited, awesome. He did what he had to do to protect his family. Done. So we can forget like the protect your. I want full Castle Doctrine, but I'm still a realist. I know this is not going to happen in Canada. Why is it so complicated why are our laws so complicated and not extremely precise to kind of remove that gray area is my question.
So there's always going to be an element of gray area because you have to write a law that's going to cover every scenario that you can't predict. So there always has to be an element of asking a judge to interpret the law and to make a decision to apply the law. But I mean, laws can be very clear and direct. Like let's turn our attention from criminal defenses to criminal offenses, right? The offense of murder, right? Intentional unlawful killing. That's murder. So that is very direct. It leaves a lot to a jury to have to decide in the moment. Did this person actually cause the death, or was it intentional or not intentional? But I'd argue that's pretty direct. So in the case of self-defense, it's entirely open to the Parliament to pass to amend the criminal code to say if someone breaks, if there was an unlawful entry into a home at nighttime, or maybe you don't even add the at nighttime part, but if there's an unlawful entry into the home, the occupant is justified in using the force he deems necessary in a moment, or that's an automatic defense to a murder charge. Parliament could do that. That takes, I think, a bit more, let's say, confidence on the part of lawmakers, because if you pass a law that says we're just requiring people to be reasonable in the circumstances, it's harder to criticize. So what you're describing would require legislatures really taking a stand, like a moral stand on this issue. But it's possible. It's absolutely possible.
So Hatim, I'm wondering here, like this, obviously we're talking about this case because of obviously a fairly well publicized case that happened recently. And I don't know exactly, how familiar you are with all the cases, but like in say the last 5 to 10 years, what is the jurisprudence on this? Like, can you recall any specific cases that might fall under this kind of a thing where someone was defending their home and were charged, and sort of what happened to them? Like, kind of what direction are we going in?
So there's a few cases that stand out to my memory. So one of them that's close to where I am. So I'm in Hamilton, Ontario, and nearby there was a man named Peter Kheir. I think I'm pronouncing his last name
came
correctly.
Up last week. Yeah.
Khill. So he was acquitted, actually. So someone entered his property, was going through his vehicle, and then the thing is, he grabbed his firearm and left his house and went to approach the person at the vehicle. So he actually got acquitted at his first trial. So that means the jury heard all the evidence and decided that he was validly using self-defense, and he was found to be not guilty. But then the Crown appealed it. The Court of Appeal overturned the acquittal. He went back for another trial, and then he ultimately got convicted of manslaughter.
Wild.
So that kind of points in two. You asked me which way things are going. That kind of points in two directions, right? The jury at first level, is, I guess, optimistic from the perspective of a self-defense advocate, because at first instance the jury acquitted him. But based on the instructions, I'm trying to remember now, but based on the instructions the judge gave to the jury, the Court of Appeal overturned the acquittal. So
is that why? Like, is there a double? I was going to ask about double jeopardy. Like, would that not be in effect here and prevent him from being charged for the same crime twice, or is it only because there was an error within the judge's instructions?
Yeah, that's exactly right. So if he was acquitted and then
and there was
that was allowed to sit,
yeah.
They couldn't just charge him again and try again. But within the time periods, they can bring an appeal, and then if they if the appeal is granted, they can.
So hold on.
Another kick at the can.
The question here, because if you look at the case of McDonald, which is the man that just had what happened in Lindsay last week or the week before, and you compare it to Kheir, the man from Lindsay attacked the intruder with a kitchen knife, and Kheir did it with a firearm. I know for a fact, as a firearm owner in Canada, I am not allowed to defend myself with a firearm. This is not, I cannot go to my course and say, hey, I want to have firearms in Canada because I want to defend myself. The only reason I'm allowed to have guns in Canada is to hunt and sport shooting. So is that what the problem is here? Because guns, I know, cause an issue with a lot of people when it comes to the court. And the second part of that question is, why is it such a big deal? If I'm a legal gun owner, why is it a big deal for me to use my firearms against an intruder that I have no idea where they're in my house?
So it's not, I feel like I've been saying this the whole time. It's not that black and white. There's a gray area.
Of course.
So there's no rule that you can't use your firearms for self-defense. I'm also a firearm owner, and I think what you're talking about is that when you do the course, they tell you can't own firearms for the purpose of self-defense.
You can't say to your non-restricted instructor,
that's so ridiculous.
Hey, why do you want guns? Because if somebody enters my house, I'm gonna shoot them. Can't say that. They're not gonna give you a license.
So your reason must officially be target practice or something. But if you have it though, you can use it just because it's there.
That's right.
That's
yeah.
So ridiculous.
So again, it's reasonableness, right? So the jury's deciding, was this person's use of a firearm reasonable in the circumstances? So some of the things that weighed, it's been a while since I've read the case, but some of the things that weighed against Peter Kheir in his situation was he grabbed his firearm and he left his house to go
down,
to go see what, to go stop the guy who was rummaging through his car at that moment. So it's always that's different than the Lindsay man.
Yeah, because what you're talking about, protection, self-preservation, and protection of property. Yes. I can see that in my head. There's no difference. Both are the same. But I understand in Canada you can't really defend your property per se. Your life wasn't in danger. That's where most of the cases reside, right? Yeah, and there's also, if I'm remembering correctly, I might be going out on a limb here, but I'll just, to the best of my memory.
Sure.
What happened in Peter Kheir's case is that part of the instructions I think that the court took issue with was what's the window of time we're looking at to assess reasonableness. So in the moment, he's outside facing this man, and then the man went to turn around and he thought he had a knife. That was his evidence, if I remember correctly. And so in that moment, is it reasonable to use a firearm? You might answer one way, but then if you look at the whole interaction and say, well, okay, was it reasonable for him to leave his house in the first place? You might get a different answer. So that also goes to that kind of affects whether or not you consider it's protection of property or protection of his person.
Because you cannot, What is the rules regarding protection of property, right? Because they obviously you can, at least in theory, protect yourself from grievous harm, but what can you do to protect your property? I assume you can't attack someone with a weapon.
So it's actually very similar. You have to believe that you are that it's your property, that you own it. You have to have reasonable grounds to believe that.
Okay.
You have to have reasonable grounds to believe that someone's either entering, taking, or damaging the property without lawful authority. And then you have to be doing what you're doing to prevent them, and it has to be reasonable in the circumstances. I believe there's case law that says it's not reasonable to use lethal force to defend property.
Okay, that's kind of what I thought.
That is just insanity to me.
Especially because it can so quickly turn into, like, if you interrupt someone who's just breaking into your car, and now he immediately turns on you, and now it's not property anymore, right? Now it's you.
Yeah, and the Peter Kill situation highlights that, right? It's defensive property can turn into defensive person pretty quickly.
Very fast,
It's not a clear line.
And I don't see it as a bad. In the instance, I see somebody going through my garage, going through my car. What's to say that the next step is not to come into my house? You know what I mean? Like, if you're ready to do it to my property, what's preventing you from entering my house next? This is where my mind goes. And if I see you outside, I'd much rather catch you outside when my family's safe inside than to even consider the possibility of you trying to do that to my house where my family is. And does the family play in the reasonable aspect to say that I've learned martial arts because I wanted to protect myself and I wanted to protect the people I love. That's why I've done martial art for more than 20 years. That's my sole reason for doing it. Is it not fair for me to say if somebody entered my house, my wife was there, my newborn son is there, I heard noises, I ended up there was a dude in my house, I didn't ask question, and unfortunately he's dead. That's not my intention, but if that's where it goes, I'll talk to God. I'll have a conversation with God later on when I meet him. But until then, I'll sleep very well at night because I protected my family. Is that something you can play on or use in somebody's defense in court?
Yeah, absolutely. It's not a trump card, but
great choice of word there.
Right. No pun intended. So the defensive person, so there's defensive property and defensive person. Defensive person is defensive self or another person. So it's completely equally valid to say I was defending someone else, not myself. And so this is where a person who's accused, when testifying, will explain why he did what he did, and he'll explain, my family was in this room. I was worried. I was worried the person might have a firearm or whatever, and I didn't want that entering the house. I figured they would be safer if I took it out of the house, and they could explain that. And then it's on their lawyer to argue that that's reasonable, and then it's up to the jury to decide whether or not it is reasonable.
There's a comment here from Bumpy Johnson. He talks about the Gerald Stanley case. Are you familiar with that one?
Yeah, somewhat. It's not a case I've looked into. It was a big deal when it happened. So they actually really upended a lot of rules in Canada as a result of that case. So what happened is it was very similar to the Peter Kill case. I think they happened pretty close in time to each other. Someone very, very similar situation of country home, someone broke in. I don't remember the details if it was in the house or out of the house. Unfortunately, I don't remember that. But essentially, the homeowner used lethal force and killed the one who had come in,
the intruder.
Right? The intruder. So, and he did get acquitted.
Okay.
And that's the end of it. As far as I know, he's now living as a free man, no criminal conviction. What happened after that, though, is that there was a big outrage with how they selected the jury. So
interesting.
At the time, there was something called, you bring in the big pool of jurors, and then you bring them up one by one until you fill up the jury with 12 people, right? Mm-hmm. Mm-hmm. So you can challenge a juror 2 ways, or you could at the time. You could challenge them 2 ways. You could challenge them for cause. So this is where you're going to say, I object to us having this juror on the panel because I think he's biased for some reason. It's kind of hard to argue because there's only so many questions you can get into with a juror to really try and pull out what their views are.
Can you ask their criminal history? Could you say, well, he's been convicted of breaking and entering, so he would be biased, or would you not be allowed to ask that?
General questions that they can get asked are things like they will get asked, is there any reason you believe that you cannot be impartial between His Majesty and the accused? Sure. There have been cases where like there's a racial element and they get approval. You have to basically get permission from the court, but they'll get permission to ask questions like, does the race of the accused and the victim affect your ability to decide this impartially? But there are defense counsel and crown counsel, I suppose, are very constrained in the questions they can ask on for cause challenges.
Sure.
So the other way you could challenge jurors it was called a peremptory challenge. So that was an automatic veto.
No reason at all.
Yeah, you got a certain number of them, and then depending on the offense you're charged with, that would determine how many peremptory challenges you got. So murder was the highest number. I don't remember what it was, but so.
And what was he charged with? Murder?
Stanley, yeah,
Stanley,
it
wow.
was. So the accusation in that case was that the defense counsel used peremptory challenges to remove First Nations people from the jury. So because the homeowner was white, the intruder victim was First Nations, and so the accusation was that he used, because it's no questions asked, the peremptory challenge. So there's this big uproar that peremptory challenges were used in a racist way. They amended the criminal code. They removed peremptory challenges altogether, so they don't exist anymore. Wow. Now the trouble with that is like, yeah, it's no questions asked. So could you use a peremptory challenge in a racial way? Absolutely, but that goes both ways. So whatever race the accused is, he can use it, and then the Crown also has peremptory challenges.
And just because it's race based doesn't mean it's not like it still might be a good thing to do from your client's perspective, for sure.
So that's it. The end result was that it limited the ability of accused to try and shape the jury panel that they're getting. But it applied both ways too, right? The Crown had peremptory challenges, so
and they don't have them either anymore.
That's right.
So I think I've got probably just one or two more questions, and we'll let you go. But about this case here, the Lindsay case, not sure how familiar with, but just based on, I mean, I know it's a huge crapshoot when you go to the courts, but what do you think about this case? What do you think are his chances? And you know, if you were defending him, what route would you go?
I have unable to answer that because they've been very locked down on the details of the case. So I'd be speculating as to what's actually going on.
Sure.
In terms of what route I would go, I don't think this is the kind of case that ends in a guilty plea. I think for good reason, anyone who's charged with, like, the Crown's not going to plead it out. And so he's going to have to take it to trial and try his best to explain why.
And to a jury.
Himself. Yeah.
Yeah, because to me, that's an easy one. It's going to suck that he's going to have to go through the 1 or 2 year of prosecution, but the guy was armed. So was he. That to me is just easy peasy. Just send the guy back home and call it a day. But
I will say this: jurors are drawn from your county, basically. It's like, I think it's the judicial district, but they kind of line up with the counties. But anyways, this guy's from Lindsay, Ontario, and so it's relatively rural, and so other people are going to be drawn from that area, and I think that also affects how a jury would react to the case before them.
Is there a possibility that the Crown could ask for a change of venue based on anything like that, or is that not? There's no avenue for that.
There are ways to request a change of venue. It wouldn't be reasonable for a Crown to request it because they think people who live in a particular area are more accepting of self-defense.
Yeah, sure. Do you got any more there, Nico, or what?
No, literally, I wanted to know if it was possible to have a provincial way to do it, but it seems like there's workarounds.
Yeah,
But
that
there's
was
not really a
I
way
found that
to
really
do
interesting.
it like they do in the US because of what you said. The criminal code is really handled by the federal government and not the provincial. But that could be something, hopefully, that somebody like, if Alberta is to become sovereign, still within Canada, but sovereign, maybe there's a way for them to bring that in to say we'll be responsible for our own criminal
Well,
law and we won't take the federal one. So,
on that note, Hatim, like I mean, obviously you would know a lot more than me how the machinery of the justice system works, but do the crown prosecutors, like how closely do they hew to these sorts of guidance from the provincial policy statements? Are they kind of like use them as a rough guide, or do they, like, if the provincial government lays down what we're talking about, what would be in effect some sort of a Castle Doctrine, not through law but through these policy guidelines, do you expect that, just based on your experience, that uh, most crown prosecutors would basically follow those pretty closely? Or
Oh yeah, absolutely. So it's the policy manuals bind the discretion of
okay, so there
attorneys.
is not pick and choose what they want to follow.
Yeah, so I used to be a prosecutor, and if my policy manual told me in this particular circumstance I can't offer a guilty plea, I
Yeah.
can't choose to depart from that.
Okay.
That's you know, maybe at the risk of losing my job, but that's like that binds what I can do in that case. So my hands are tied in that situation. So the provincial government could tie the hands of prosecutors and direct them to withdraw cases where certain circumstances are met.
So they can't
so there's
change
a
the
way.
law.
So
They
there's a
can't change
way.
the law. Sorry, go ahead, Nico.
No, all I'm going to say is there's a way. So
Yeah, that's
basically,
kind of
not by changing the criminal code, but by doing exactly what you're doing and tying the hand of the prosecutor at the provincial level. I love it.
basically guiding how they interpret the law rather than change the law itself.
Yeah, that's part of the constitutional balance that our constitution struck, where the feds get to make the criminal laws, but the provinces get to enforce them. And so that's validly within the authority of the province to decide what to do in that situation.
And that would not be considered circumventing the federal law by the feds. They wouldn't take provincial governments to court over this, in your opinion, at least?
Well, let me give you a different example. This isn't provincial federal, it's all within the feds, but
Yeah.
drug offenses, right? So it's a crime to possess, whatever, all the illegal drugs, right? So it's a crime to possess fentanyl, let's say. Now, this is different because the federal prosecutors handle drug offenses, but during COVID, maybe still now, I don't know if it's changed, but certainly during COVID, there was a direction that went out that if someone is charged only with simple possession, withdraw the offense. There's no public interest in proceeding with the prosecution. So the law says it's illegal to possess the substance. The policy is that we won't proceed with that charge. And so, that's all within the feds.
Yeah.
But, that still applies if you separate it out. The federal criminal code can say, this is the rule for self-defense. This is the offense of murder. But it's open to the province on the policy level to say, we won't prosecute under these circumstances because it's not in the public interest.
So, that kind of sounds like an almost identical example based on what we're talking about. Essentially, they didn't override federal law, but they were able to sort of, I guess, twist it a little bit in that in effect had an overriding, maybe not, by the words, but in practice, it was sort of overriding. So
yeah,
it sounds like there actually is some room for provinces to actually make real and legitimate headway on the issue like Castle Doctrine.
Yeah, I believe there is. They can decide how they want to handle these offenses.
That's really interesting.
I like it. I didn't think it was possible, but good on you. Thanks for letting us know. Thanks for accepting my invitation. Thanks.
Yeah, this is a great chat. I appreciate the time, Hatim.
Yeah, thanks for having me on.
Yeah, we get a lot of comments here that we didn't take just because we were talking, but like the audience here is they're definitely invested in the conversation. They had a lot of positive response to the things that you're saying here. Yeah, as Bumpy says, great guest here.
Okay, great to hear.
It's a great way to finish, right?
Yeah.
Finish on a compliment and a real one too. It's not a bad one.
Who doesn't like a
I'll take it.
Who doesn't like their tires pumped once in a while?
Well, thanks again for being on the show, and maybe we'll have you on. I'll keep you on tab because I always like to have experts show up when there's something in the news that is that needs our attention, and if that
Friend of the
happens,
show.
I'll put you in the Rolodex. You're old enough to know what a Rolodex is, right?
We'll have our people call your people. Our people.
Feel free to reach
Yeah.
out.
So that's me calling you, basically. My
Yeah,
people is me. Thanks again for your time.
Thanks.
Okay, take care, guys.
See ya. Yeah, quality guests, man. We give you credit where it's due. To you
That is cool, though.
for getting these guys.
Yeah.
The quality of the guests on this show has been really high, and I think the audience
Maybe because we're so retarded, you went
yeah.
everybody sounds super intelligent.
You know what? Like though, we're a bunch of goofballs, but I think we get a lot out of these guys because I think we ask decent questions. Mostly just questions I feel like the audience are listening. And sometimes a lot of the questions will come from things that I'm seeing here. But yeah, it was actually a really informative chat.
He's a clever guy. I like what he said, to actually change it on the provincial level by kind of forcing the prosecutor not to go after those type of offensive as long as there's an intruder. The guy defended himself. You know what? Just let it be. Don't touch those ones. I like. It's not bad, actually. It's pretty clever.
And in fact, I mean, changing the law would be really hard to do and take a long time. But this is something that could be done very quickly.
Daniel Smith could do that, and the Alberta level is basically what I'm hearing. But I think the fact that he was a prosecutor before is helping him understand how they actually come to those conclusions. So I think I got a good guess. We're definitely going to see him again. Like I've enjoyed his. That's very clever. Very clever.
Great guess. And even as he was describing that sort of backdoor solution, I was thinking in my head, I was like, but because I was thinking it was guidelines, and you could still get a rogue prosecutor who's just ideologically refuses to go by the guidelines. But it was really interesting to see that he said, no, you basically have, like, there's no discretion. If they lay a guideline down, you have to go with it regardless of how you feel. And so to me, that means there's real teeth. There's real ability for provincial governments to do something here. I think the drugs example he gave was like a perfectly aligned to the issue because it's the exact same thing. The federal law says one thing, the federal law never said that it was illegal that it was legal to hold fentanyl. And according to federal law, anyone being caught with fentanyl has to be charged. And yet the provincial governments, I'm assuming in like BC especially, put out a directive to say, no, anyone found with, X amount, just let them go. You can't charge them. So essentially they are overriding federal laws through the back door, though. There's no reason you couldn't do it on this issue. And in fact, this is actually be a popular way to do it.
You really like that backdoor.
The backdoor, the backdoor solution.
You keep on talking about going backdoor. This is.
Joe says, "Does Canada have jury nullification? Do you mean like are they able to do it? I believe they're not. So and I guess
I'm already looking into it.
Right now. Look into it. But correct me if I'm wrong, Joe. For context, I believe it's if the jury believes that someone is guilty, but they vote not guilty because they disagree with the law itself. I believe is what jury nullification is. And I don't believe that is, for some reason, I remember looking into this a little while back, and I'm pretty sure it's not allowed. So it is allowed?
Yeah. So basically, it's happened. The latest one would have been, it seems like it was in August 22nd. Oh, no, that's actually, hold on, recent on legal reform. It seems that it's possible, extremely, extremely rare. There was a case in 2001 on jury nullification, but it seems like it's extremely, extremely rare, but it is possible.
I think the lawyer's not allowed to argue for it. Like if he started to, if he was the lawyer and his closing arguments, the defense lawyer was saying something like, you can vote not guilty if you just don't agree with this law, I think the judge would stop him